everybody. Welcome to Your Right to Know with Tony DeFazio of DeFazio and Ziden, and the final part of our 5-part series as we take a look at the Bill Cosby situation that is all over the news. What we're talking about today is bad acts and being able to prove bad acts in the case of this particular case, going back over time and tendencies that Bill Cosby might have. Tony DeFazio is here to kind of shed a light on that and give us a little bit more insight.
Well, in this circumstance, there are at least 50 women that have come forward that say that Bill Cosby has drugged them and had sex with them in the past without their consent. And the time frame goes back to the 60s. So you're talking about over a 30 or 40-year period where he has basically, quote, done the same thing that he did in this case. So the question is, how much of that can they get into this case? Well, normally, you cannot use prior bad acts of a person in your case if you're a prosecutor, because you don't want the jurors to say, he's a bad guy, let's convict him of being a bad guy. They only can convict someone of committing a crime. So they're not allowed to bring in to show what they call propensity, that he has a propensity to drug women and have sex with them, or commit murder, or whatever. But there are exceptions in New York, and mostly throughout the country they're similar, where there are times when you can bring in prior bad acts to prove certain crimes. The example I would give is if you have someone who's charged with a murder, and it turns out that the reason they committed the murder, or the motive, was that they had, this person owed them money from a prior drug deal. Then you can bring in evidence that this defendant had committed this drug deal in the past, which would be a prior bad act. But you can use that under that circumstance because you're trying to show the motivation. You know, the same thing is if somebody was accused of shoplifting at Walmart, and their defense was, well, I didn't know that I had forgot, you know, all this stuff underneath the cart. And they could say, well, you know, that's interesting because 6 months ago you got convicted of shoplifting at the same Walmart. We're doing the same thing. So that's an absence of mistake. It's another reason, another way that you can bring them in. There is also a third, and it's kind of open-ended. As long as you're proving something other than propensity, you can use it, their state of mind, et cetera. But in this circumstance, what they're going to try and establish is that Bill Cosby had a modus operandi when dealing with women, and that he would convince them to come to his house, and this almost always takes place at his house, wherever his homes were, all over the country. He gives them some wine, he spikes the drink, or sometimes gives them actual medication. The drink is spiked, and the person becomes incapacitated, and then he has sex with them. And that is what the modus operandi of Bill Cosby will be, and there's certainly going to be an attempt, because they need this for their case, to bring in at least some of these women who have similar type of allegations against Bill Cosby to prove that this was his modus operandi and this is why he is guilty. But there is a problem with that, and it's the due process clause. It's what I spoke about. You cannot prove that someone is guilty of a particular crime based on the fact that they have done it in the past. You know, you've done 6 murders, doesn't mean you committed the 7th murder, drug deals, etc. Rape is no exception. So there is a balancing act that the court will have to do. And the standards differ somewhat, but in New York, you have to determine whether there is the prejudicial value, and this is what they call it, the probative value, in other words, how important this is to the case. How much does it really prove that this person is guilty of this crime is weighed by the prejudicial effect. And if you march 50 women into that courtroom to say he drugged me and had sex with me, it's going to be very difficult for him to win that case, because the prejudicial value of 4, 5, 6, 7 coming in and saying it, it's going to make it very difficult for them to believe him. And that's where this balancing act comes into effect. So the judge at some point before this case goes to trial, and I expect it will go to trial, is going to have to make that determination. How many of these women are going to be allowed to testify? What are they going to be allowed to testify about? And there's certainly going to be a balancing test. The thing about the prosecution is, though, the prosecution is going to be able to pick from 50 which are the best 3, the best 4 that fit my circumstance. Who are the best witnesses? So from that standpoint, the district attorney will whittle this down, get to, I would bet, somewhere about 10, which is not going to be allowed. Get the 10 best, bring them in, and then put it to the judge and let the judge whittle it down some more, so you end up with 3 or 4 that are going to be allowed to testify. Hopefully from the prosecution it'll be the best. But it presents another problem. And the problem is that when you build your case based on not just your victim, but these other 3 or 4 victims, any one of those victims has a problem with their case, it could knock out your whole case. Because none of these other people were really investigated because they were very late. Some of these didn't come forward for 30, 40 years. There's been very little investigations. If it turns out that one of them is lying or making it up or they cannot be corroborated or something they said is wrong and it can be disputed, well, that's going to kind of put a hole in their whole case, because the defense attorney will look at it and say, you've got 5 pillars of your case. If one gets knocked out, the case falls. And that's kind of what they're going to do. So it's a double-edged sword. They have to be careful when the prosecutor decides who they're going to put forward, because if they put forward somebody not credible, they could wind up losing everything.
Your oversight, your feelings on the case, what do you think is going to happen?
Well, it's definitely going to trial. There's no plea bargain in a case like this. He's got the money and the wherewithal to investigate everything. He's got millions of dollars at stake. His entire fortune is at stake from a civil standpoint, so he will fight this, I think, with everything he's got. The case itself is weak, and I think there's going to be some problematic. I would like to see, it's kind of early to say, because there's going to be some pretrial issues about the politicizing of the DA, about how many other women can testify. But my feeling is that after we see all that work itself out, that you're going to have a trial, and depending on how many of these other women are allowed to testify, I think will determine whether or not he is convicted or not.
Interesting stuff, and it's all over the news. So you're getting some insight information from Tony DeFazio as you look at what's being presented to you throughout the media across the country on this Bill Cosby case, and it'll be interesting to see exactly how it turns out. This is Tony DeFazio from DeFazio and Zeiden, and you're watching Your Right to Know. Thanks for watching. We'll see you next time.